My Lord, I have filed this public interest litigation in connection with amalgamation of 6 public sector banks with 4 public sector banks with effect from 1/4/2020 as per Gazette notification number 133 dated 4/3/2020, and I challenged it on the ground that it is illegal, it violates Reserve Bank of India guidelines, Banking Company Acquisition and Transfer Undertaking Act 1970 and 1980 and Honorable Supreme Court judgment. My Lord, I am explaining this amalgamation, how it is illegal, by referring to Honorable Supreme Court judgment in case of New Bank of India, Employee Union versus Union of India. Lordship may refer page number 26 to 30, my Lord. About 27 years ago, my Lord, New Bank of India, which was nationalized in the year 1980, and during 1992 to 93, New Bank of India has incurred heavy losses and its capital is completely eroded and they were unable to pay the depositor. Hence, the government declared moratorium and requested Reserve Bank of India, as per section 9.1 of Banking Company and Acquisition Act, RBI has prepared the amalgamation scheme, and the central government, as per section 9.6 of the Banking Company Acquisition Act, placed the amalgamation scheme in the parliament, and subsequently after the parliament approved the scheme, it was implemented and the New Bank of India was amalgamated with Punjab National Bank. My Lord, it is purely left to the rights of the parliament to decide whether to implement or whether any modification is required or it should not be implemented. My Lord, in this regard, I am again referring the Honorable Supreme Court judgment in New Bank of India, Employee Union versus Union of India, wherein, my Lord, if private sector bank is sick under moratorium, then as per section 45 of the Banking Regulation Act, it is amalgamation scheme is prepared by Reserve Bank of India, whereas if public sector bank is sick under moratorium, then section 9 of the Banking Company Acquisition Act is applicable. My Lord, what is the difference between 45 of the Banking Regulation Act applicable to private sector bank and 9.1 section applicable to public sector bank under sick under moratorium? Honorable Supreme Court held that section 45 of the BR Act applicable to private sector bank and section 9 of the Banking Company Acquisition Act, both are pari materia. Lordship may refer page number 29, my Lord. But the difference between 45 and 9, my Lord, Lordship may refer page number 30. As for 45 of the BR Act, the amalgamation scheme prepared for private sector bank is simply placed in the parliament and nothing further. Whereas as per section 9.1, the amalgamation scheme prepared for public sector bank is placed in the parliament for 30 days in both the house, and only after the house, if it is approved or if they want some modification or if they declare that it should not be implemented, it cannot be implemented at all. Any modification or approved, it will be implemented. So only the parliament is the supreme authority to decide whether to implement or not. My Lord, in this regard I refer Honorable Supreme Court judgment in case of 63 Moon Technology Limited versus Union of India, in page number, Lordship may refer page number 78, my lord. In this regard, my lord, Honorable Supreme Court has struck down the compulsory amalgamation of a healthy company with a weak company on the ground that it is not necessary, not essential, and against public interest. The Honorable Supreme Court struck down. My lord, in this regard, I am again referring the Reserve Bank of India guideline, my lord, dated 13/4/2017, my lord. Lordship may refer page number 51 and 52. In that, Reserve Bank has parameters under risk 1, risk 2, risk 3, threshold limit. My lord, if a public sector or private sector capital is below the risk 3 threshold limit, then Reserve Bank use the amalgamation tool. If the capital is sound and well performing, RBI has no role to prepare any amalgamation scheme, my lord. In this regard, my lord, now the 6 public sector bank amalgamated with 4 public sector bank as per Gazette notification dated 4/3/2020. My lord, the 6 public sector bank, namely United Bank of India, Oriental Bank of Commerce, Andhra Bank, Corporation Bank, Syndicate Bank, and Allahabad Bank. All the 6 public sector are sound capital and are well performing banks. So RBI has no role to prepare any amalgamation scheme. So also when RBI has not prepared any amalgamation scheme, then the first respondent cannot place anything in the parliament, and parliament also has nothing to approve or modify or reject. So all these mandatory procedures as per Acquisition Act 9 has been simply bypassed, and the first respondent using a Gazette notification simply amalgamated 6 performing public sector with 4 public sector is illegal against the Banking Company Acquisition and Act, RBA Act, Honorable Supreme Court judgment, and hence I pray to quash the amalgamation scheme. My lord, about 27 years ago, New Bank of India was amalgamated with Punjab National Bank. At that time, New Bank of India was sick under moratorium, and as per section 9.1, Reserve Bank prepared the amalgamation scheme, and as per section 9.6, central government placed the amalgamation scheme in the parliament, and only after parliament approved the scheme, it was amalgamated. Now, my lord, after 27 years, now then no bank is sick and moratorium. RBI has not prepared any amalgamation scheme, and the government also nothing placed in the parliament. Government also has not made any approval, but without parliament approval, nothing can be implemented. But all these mandatory procedure is bypassed, and the first respondent compulsorily amalgamated. This well-performing bank is illegal and violate Banking Company Acquisition Act, Honorable Supreme Court judgment, RBA Act, and hence it is liable to be set aside, my lord. And next point, my lord, Payment and Settlement Act 2000.